Hey there, thanks for joining me. My name is Gary Pritchard. I'm one of the lawyers at Glidewell Laboratories. Today I'm going to be talking about how to navigate the shark-infested waters and keep your hard-earned money out of the pockets of greedy plaintiff attorneys. First, the legal disclaimer. This is not legal advice. I'm not your lawyer. These are just my observations over more than 20 years of representing companies against the forces of evil. Look, one of the largest exposures that a laboratory business can have is a lawsuit from its own employees. One minute they're a beloved team member, the next they're suing you. Why do these employment lawsuits cost such big money? For one thing, your own lawyer is going to be expensive. Employment lawyers are specialists and they think that they're worth a lot of money. But also, most of the employment laws have fee-shifting provisions, which simply means that you could end up paying two lawyers, your own and the employee's lawyer. These fee-shifting provisions are great for plaintiff lawyers, but bad for your lab business. Today, I'm going to talk about two relatively easy steps a business can take to protect itself from employment lawsuits. First, I recommend that you require harassment, discrimination, and retaliation training for your supervisors. The fact is, employers are strictly responsible for the actions of their supervisors. So it's a great idea to take an hour or so every year and train your supervisors about discrimination, harassment, and retaliation. A supervisor needs to know that they cannot discriminate, harass, or retaliate against a person on the basis of what is known as protected categories, such as race, color, national origin, religion, sex, etc. This simply means that you cannot take any job action like hiring, firing, or promoting because of these personal characteristics. You can't refuse to hire someone because of their race. Make sense? Seems basic, right? Unfortunately, the basis of many jokes are these same personal characteristics that are protected by law. That's why your supervisors need to be trained not to joke around employees and about their personal characteristics. That could be perceived as discrimination. Make sure to document your training. Give your supervisors a certificate of completion and put a copy in their personnel file. I will see if we can videotape some of the training that I do and make that available for you. The second thing I want to talk about is that you should have an anti-discrimination, anti-harassment policy. Employees should sign the policy and you should put it into their personnel file. The policy should define discrimination and give some examples. It's also vitally important that the policy require the employee to immediately report any harassment. In my experience, the first claim of harassment usually comes at the termination of employment. However, if your lab has a policy in place that an employee is required to immediately report harassment, then the employee cannot say that they were not warned about how to handle harassment. The employee simply failed to avail themselves of the remedy that you provided. How can they complain about harassment if they didn't follow the policy that they signed? If you're already providing training to your supervisors and already have a harassment and discrimination policy in place, congratulations. You've taken the first steps to beating a couple of lawyers, yours and theirs, out of some money, and you should feel good about that. Good luck out there, and be sure to check out the Gary the Lawyer column in Glidewell Lab Perspectives magazine.